Hello, everyone. Good morning, good afternoon, good evening. Hope it's not too late for you or too early for you, but you're all very welcome to our second webinar on preventing and responding to illicit intercountry adoption practices. We had a very interesting first session, which was very ably moderated by Nigel, whom I welcome also today. And I see another number of very familiar faces because they were present already during the first webinar, and definitely because this is in a way a continuation of our first webinar, we are very happy to see them again. This series has been organized by Child Identity Protection, CHIP, with Intercountry Adoptee Voices, the Institute for Inspiring Children's Futures, together within that, and that is within the University of Strathclyde, and of course, inevitably and very welcome, UNICEF. As the former UN Special Rapporteur on the sale and sexual exploitation of children, which was between 2012 and 2014, 2020. And now the president of CHIP, I always felt the whole issue of illegal adoption has been very close to my heart, and I've been trying very hard to find solutions. I've been advocating for child-centered approaches to the solutions, which are also available in adulthood. But we'll continue the search for solutions together with all the participants today, because it is still, unfortunately, a topical issue. So I feel very honored to be moderating this webinar together with an esteemed panel of speakers. But before going into the theme of this webinar, I just wanted to make a few remarks relating to housekeeping. The bios of the speakers will be in the chat function and also available on the CHIP website under advocacy, so we don't have to read them out, and speakers don't have to present themselves. We will end our session, obviously, with the opportunity for participants to raise questions, and we will try to, the panel members will try to answer them. We obviously, because we are very many today, we have over 250 registration. We have to reserve the right to prioritize questions, and that will be for the organizer to do. But we will be selective in the sense that those questions which will be most relevant and helpful to the greatest group of persons will be addressed primarily. And of course, inappropriate questions and direct personal questions will not be handled. I also should say that we're very grateful to Ariane, who is one of our speakers. She is traveling from Belgium to Italy, where she will meet the Central Adoption Authority. And during the time, she will make herself available, but because that is a limited scope in time, we will have these questions immediately after her presentation. And of course, I should mention we are extremely privileged to having Minister Senor Alejandro Aguilar Brevis, who is the Chilean judge responsible for dealing with illegal adoption cases, present with us today. We have, for that purpose, organized interpretation, and that can be assessed at the bottom of your screen. You're probably familiar with that function. And then finally, I already said that at some point I will have to leave, and then Mia will take over from me, our executive director of CHIP. So let me now very briefly come to the substance. First, a little reminder of the first webinar, which dealt with state obligations in the context of past cases, even prior to the entry into force of the most relevant text or international legal instruments, like the Convention on the Rights of the Child, like the Hague Intercountry Adoption Convention. And even the optional protocol, to the extent that there's reference to illegal adoption by obliging member states to criminalize forced consent. I mean, not genuine consent, but consent by relinquishing parents to give away their child for adoption. So there were several challenges were identified, but also opportunities. The recording will be made available on the Child Identity Protection website under advocacy section. So later on, when you have time, you will have an opportunity to go through this again. So now moving to the second webinar, it's about current cases. So that's the distinction, past cases and current cases. But as we have already concluded, there's no strict separation between past and current cases, because the suffering of the children who have been illegally adopted continues as long as there's no solution has been found, whether it's long time ago or into adulthood, that the suffering remains. And therefore it is very important that when we address current cases, we really try to seek solutions which also addresses the past. And some of this is, as I said, some of the solutions have been have been suggested in the previous webinar, but we'll continue to search for solutions. But we will try to look for forward-looking approaches, collective efforts with the Hague Convention through the special commissions and dedicated working groups to identify at least minimum standards. In response to current illicit intercountry adoption practices, states have introduced different moratoria, laws and policies to sanction a rights violation, and that's a good thing. Also, national jurisprudence has been developing. The Committee on the Rights of the Child has been extremely active also in looking at solutions in their recommendations to state parties. And we are, of course, looking forward to the upcoming general comment on access to justice and effective remedies, which obviously has an important relationship to the discussion we will have today. So having said that, we're all anxious to hear our speakers, and I will start giving the floor to Benoit van Keersbilk. I will only say that he is a member of the UN Committee on the Rights of the Child, which is already a big responsibility. But I will not enter into further details on all the other responsibilities Benoit has. Please, Benoit, we're anxious to hear you.
Thank you so much, Maud, and thank you for the organizer. I think that this is a very important series of webinar on a very topical topic, as it was already said. So I was asked to give some presentation and some information about this upcoming general comment on the right of the child to access to justice and to effective remedies. A quite long title, but every word is important in this title. But first of all, I just want to clarify the fact that this is not yet adopted. It is still an ongoing process, and the committee is hopefully going to adopt it this year, depending on the meeting time that we will have ahead of us until the end of the year. But The drafting is very well advanced, and we are now at the final stage. We have had several consultations, and I know also that many people and organizations involved in the topic of intercountry adoption, and especially on the side of fighting against illegal practice, have been involved and contributed to this drafting. So we have a lot of material there. And so what I'm going to present is not yet the final version, but it's quite close to the final version that will be adopted soon and hopefully will be useful in the context of what we are discussing. Just for the ones who do not know very well what a general comment is, allow me to recall that it's a document adopted by the Committee on Rights of the Child, which is a global overview, a comprehensive overview on one specific topic. We have already 26 of them. So on different specific rights or categories of rights or categories of children. And the idea is really to give some guidance to states on how to interpret and how to apply the Convention on the Right of the Child. And it may be surprising that the committee only deals with access to justice now, more than 25 years after the adoption of the convention. And because this topic is really at the center of the convention, you don't have children's rights if you don't have implementation rights. You need mechanism to ensure that the rights of the child are made real and effective. And so the idea of this general comment is really to support the states in making sure that there are mechanisms in place, on the one hand, to try to prevent the violation of children's rights, and on the other hand, to make sure that when violations are happening, there is a remedy to stop it, if possible, or a remedy to try to repair what could be repaired at the end of the day. I don't have to explain at length that children's rights are violated on a daily basis for most of the children who experience a violation of their rights. Accessing to a remedy is difficult. There are so many obstacles, so many difficulties. We cannot enter into all of them, but when we talk about adoption, illegal adoption, we see all the difficulties that children can face trying to make their voice heard by a judicial system, that they have access to a lawyer, that the lawyer is well trained, capable to listen to the child, to bring the case to the right audience, and so on. So we see all the difficulties and the obstacles that children are facing in this kind of situation. And we know that there is a need to ensure that every child has a proper, effective, accessible justice system that is available, and that doesn't add to the burden and the harm that the child has already suffered. This general comment so deals with this idea of making sure that on the one hand, the justice system are adapted to the situation of the children. Usually, and this is not something new, but the justice system has been built by adults, logically, but also for adults. And children were not at the center of this discussion most of the time. They were very often forgotten, and so the system are not built taking into account the needs and the capacity of the child to address a judicial system. So the idea is, on the one hand, as I said, to force and push states to adapt their system and make sure that those systems are in line with children's needs, but also to support children to access this system and to put in place different means to ensure that that children may have the right information, access to a lawyer, but also sometimes very practical support. And it's also sometimes support from different professionals, not only lawyers, but social workers, psychologists, and we know how important multidisciplinarity is in this context. So that's one of the most important objectives, and I see that the time is running fast, so I need to try to highlight a few important topics that are really directly in line with intercountry and illegal adoption. First of all, there is in this general comment the idea of the fact that a state has a responsibility not only on its territory, but also for what is happening outside of the territory. So there is this dimension to make sure that states are responsible, but more largely than only their territory. We ask states to ensure that in all procedure, the decisions are based on a due process, and that the rights of the child are guaranteed at all levels. When there is an international crime, which is the case of inter-country adoption, illegal ones, states should also make sure that their decision has an effect more globally, and they look at what is happening in other contexts. And then a very important dimension to look at the reparation. If possible, we need to see and to ensure that there are remedies to stop a violation before it happens or before it has all its negative consequences. So this is very important when it is possible, but when this is not possible, the question will be how to repair. And the general comment gives some orientation to the states, saying that you have to repair individual consequences for children themselves. They have to access their files. They have to be able to be supported in this procedure. But they also need to see what kind of reparation you can provide when these violations happened. Maintaining or trying to restore the link with the family of origin when this family is still exists or can be found. But sometimes it's also supporting the psychological harm that the children or young adults or adults have been facing because of this illegal adoption. So there is a need to ensure there is rehabilitation, recovery, and reintegration, a dimension of compensation every time that it is in place, and also making sure that the risk of repetition doesn't exist anymore. So this is also crucial. And finally, the last point, and there would be much more to say about it, but the importance of looking at the time limits. I know that it was addressed during the last webinar, but this general comment also invites states to look at the time limit and to make sure that there is a possibility to challenge decision even long time after they have been taken. I stop here, but I'm really open for any question that people would have on the topic. Thank you.
Thank you very much, Benoit. Not in the last place for having so carefully watched your watch. You stayed perfectly within the time limit, and within this short time limit, you have been able to lift the veil of the very important general comment that everybody is looking forward with great expectations, in particular in the context of illegal adoption. And you have made it very clear how important the implementation of all the rights in the convention must pass through access to justice, and what the particular challenges are in relation to illegal adoption. So thank you very much, Benoit. That was very, very good as a starter. And we now have the pleasure, and I welcome again Laura Martinez Mora, She is the first secretary of the Hague Conference on Private International Law. And we know that she is really a key figure in everything which is going on there in The Hague in the context of illegal adoption, and since a long time. So we're really going to benefit from her knowledge. And I give Laura the floor. Laura.
Thank you very much, Maud. Good afternoon, good morning, good evening to everyone. It's a pleasure to be here. Thank you very much to Chip for the invitation. I'm going to share a short PowerPoint to help for what I'm going to present. Hopefully you can see it now. I think so.
Yeah, we can see it.
Thank you for the confirmation. So I have been asked to speak about the ACCH toolkit for preventing and addressing illicit practices in inter-country adoption. Before doing so, I know many of you already know the ACCH, the High Conference on Private International Law, but for those who are not so familiar, just key points that I think are important as well for the discussion afterwards. We are an intergovernmental organization, we are independent, and we have a legislative mandate. It's like a parliament. We draft international treaties like the Convention 93 Adoption Convention. And also what we do, once you have a convention, you have to monitor its practical operation. But we are not a court or a tribunal, and we work on the civil aspects of the law, not on the criminal one. So this is, I think, very important to take into consideration in what we are discussing here. There is almost 40 ACCH conventions, and it's not only on family law area, but also on legal cooperation and other questions. And all of them, they want to have a practical impact and as well benefits for persons, families, and companies. That's also very good because our mandate is quite broad. It's not only adoptions. And here we are, one of those conventions, one of the main ones is this convention in 1993. And I always want to refer to the title, it's very important. This convention, the first thing that it aims is to protect children. And then if there is a need to have an inter-country adoption, then let's do it correctly and let's cooperate and work all together. And it's also at this point important in the discussion that we are having today is why do we have this convention? We have heard in the webinar last week from different adoptees, very important voices, and we are hearing them about the problems, about the issues that they were in the past. It's also important to know that this convention was done because they knew there were issues. And that was starting late 60s, but afterwards as well, we saw the number of inter-country adoptions was growing exponentially. There were many abuses, and those abuses were already raised to the ECOSOC Commission of the Human Rights Council at the United Nations level. We also had Interpol mentioning those abuses, Defense for Children International, International Federation of Human Rights, Terre des Hommes. All these international organizations or NGOs at that time were saying, hey, there's a problem, there's abuses. We need to do something because there is no guarantees, there is no procedures, there is no monitoring. So we have to take into consideration that this convention starts from now. So what has been changing is who is raising the voice of alarm. Now it's very important because we also have the voices of adoptees and as well in an increasing way as well first families. And to understand as well why this convention is there, it's also important to have the link with the Convention on the Rights of the Child. They were both drafted at similar times with a similar idea and aim. This convention establishes minimum safeguards. It also gives us a framework for cooperation. If you do things properly according to the convention, if an adoption is needed, then in an indirect way, you will be preventing abuses. And then you have, we deal at the ACCH, we deal with private international law issues. I will not go into that, but one of the elements important of private international law is the automatic recognition of the adoption decision. And this can only be done if you did things correctly according to the conventions. As I said, we draft conventions, but we also try to help states to implement those conventions. There's a number of tools that you can see here that have been adopted by our members and contracting parties to the convention, and that are non-binding. The convention is the binding instrument. All those instruments are non-binding, but can really help to tackle the issue. And one of them is the toolkit. And this, I'm going to concentrate now on this toolkit that was approved just a couple of years ago after a long period. It deals with preventing one side and then addressing illicit practices. All the work that we do at ACCH is not us at the Permanent Bureau. It is we start with a working group. Some of you that are in the audience are here in the picture as well. So we have mainly our counterparts are governments, but we also have limited numbers of observers. Since some years as well, we have associations, international associations of adoptees working with us. So that's as well very important. And then it's the whole organization, all the members. So that's approximately 90 states, and as well the contracting parties. So the contracting states, that's 107 that have to approve our tools. So it's not just a bunch of people. It's tools that are approved by a large number of people. And in this toolkit, you have different things. You have a fact sheet to try to identify the illicit practices. And those fact sheets that are targeted to the situation now, to the standards now of intercountry adoption. Then if you are doing an adoption, you want to have a checklist to see if you did things correctly. You have one in there. And if you see that there is a problem, you stop, you don't move forward. Then there is a model procedure to respond, and then some guidelines to enhance cooperation. Some ideas, scope of application of this toolkit. Our mandate of what we work is for the adoptions under the convention. And that's not from 95. You will have to see country by country when the convention entered into force between different countries. Then states are also today encouraged to apply this toolkit even if they work with a state which is not a contracting party. So you can still apply it. And then if we look at the past, then the last arrow here, they agreed that states might consider referring to the toolkit in dealing with suspected illicit practices arising from adoptions that occur in the past or outside the convention. So that's also important to take into consideration. The fact sheets identify 11 main broad topics. Of course, there is more, like sale and trafficking in children, circumvention of the convention, all the financial aspects, issues regarding identity, forgery and falsification of documents. They all have this, and they have illicit practices and as well enabling factors. Illicit practice will be falsification of documents. Enabling factor will be maybe I don't have a standardized form or I don't have the legislation. This per se is not illicit, but it's the path to get illicit. Then we also have in the part 2 something very important, and it appears like this in the toolkit. And I think I'm going to read it, is where at any step in the intercountry adoption process, reasonable doubts of illicit activity arise, central authorities should immediately suspend any further decision regarding the child's life plan and refer to the another part of the toolkit. So it's very clear guidance to states of what to do if you see that things are not going well. We are speaking about adoptions today now. Then we also have the part of once, regrettably, we think there is illicit practice, what are the steps? So we focus on step 1, disclosure and recording, step 2, investigation, step 3, possible actions. And in between that, you have to protect the person, you have to give services, and you have to see how to inform. And the guide gives us all this. The last part, and I'm finishing here, they have some guidelines as well about cooperation. coming back again to the beginning of my short speech, the convention has the word cooperation. We should all work together. So this is as well where we try to have it in the toolkit. And I will stop here, and I will thank you all for your kind attention. Thank you very much.
Thank you very much, Laura. You again, very careful to watch the time. So things are going exactly according to plans. And I thank you for a very interesting presentation of the work of the Hague Conference, in particular the toolkit which the working group had developed with very practical guidance for states, how to prevent and address illicit practices, and that is extremely helpful for not just governments, but for everybody to read in order to be effective in this area. I also heard the strong call for cooperation between states, which you expressed a number of times. So thank you very much, Laura, for this very interesting presentation. And the next speaker on my list is Rachel Harvey. She is a senior advisor, child protection and migration, global lead violence prevention and response system in UNICEF. So thank you very much for being with us so late in the evening. But we are absolutely keen on hearing what UNICEF has to contribute to this very important topic we are discussing today. So please, Rachel, you have the floor.
Thank you so much, Maud. And UNICEF is really delighted to be partnering on this webinar series. It's really a pleasure for me also to be joining the panel today. Unfortunately, we know illicit adoption is not an exception. It is, we could say, a predictable outcome when systems that really should be providing safeguards are weak or treated as obstacles. And we really see adoption as sitting at the intersection of justice and child protection systems. And illicit adoption is a failure not only of the justice system, civil and administrative, but also a failure of the child protection system as well. When we look at civil and administrative remedies, they're of course independent of criminal prosecution, and even where prosecution is impossible due to time limits or jurisdictional barriers, states must remain obligated to provide these effective remedies and reparation to victims, as we've heard. But what we see is that children are frequently invisible in the civil justice systems. And it's clear that weak civil justice responses are leading to this avoidable family separation, unsafe placements, prolonged uncertainty, and rights violations. But what we're also seeing is across the majority of development contexts in which we work, civil justice system strengthening has received insufficient attention and insufficient investment. UNICEF's technical brief on child rights in civil proceedings, which sits under our Reimagined Justice for Children agenda, and the technical series calls for this investment as a core component for child protection across these contexts. The brief explicitly addresses strengthening civil justice as it pertains to custody, care, proceedings, adoption, child support, and cross-border family disputes, and calls for 6 critical components to be in place. And today we wanted to share a little bit more information about those components. And as you will hear, this is very closely aligned with the forthcoming general comment that Benoit discussed, and also with the HCCH toolkit that Laura presented. And my colleague Grace, who worked very in the lead on this piece, has dropped the link into the chat box. So the first of those components, and you heard Benoit say this, is legal empowerment. Without information, justice can't be sought. So we need to ensure that you have right to access adoption records, origins and identity, that you have a clear explanation of what your rights are, what the remedies are, what the procedures are, and that this communication is child-friendly language and family-friendly as well. The second piece is, of course, legal aid, timely and quality access to legal aid so that children have standing representation. They're recognized as rights holders in this process, not objects, but also that birth families have standing to challenge unlawful adoption. And independent representation should be available where those interests do conflict. Justice systems have to be, does not mean power or wealth to access legal representation. In 2025, out of the 190 countries that we worked in, 113 did report that children are provided with access to justice and legal aid by law and in practice. But we also have to note that priority for legal aid was for child victims and children in conflict with the law. children in civil proceedings were far less well covered and provided for. The other area is child-friendly courts and proceedings that are adapted to a children's age, capacity, and experience, and this needs careful, humane handling, not adversarial rigidity. And judges are really the essential gatekeepers of access to justice, not only recognizing that illicit adoption is a serious rights violation, but allowing for standing for children and affected families, refusing shortcuts that undermine safeguards, ensuring those remedies are available and enforceable, and interpreting time limits and procedural rules in a rights-consistent manner. So we also have good news here that capacity building and specialization is steadily expanding, again in 113 countries. All of them reported having specialized trained professionals, including for interviewing processes, and 111 of them reported child-friendly court proceedings being in place. But again, it's often criminal justice being prioritized for training and child-friendly proceedings. The challenge is to ensure that all professionals in the justice sector have those skills, attitude, and knowledge on child rights, and that they apply them in all cases involving children, including civil proceedings. The other workforce is the social service workforce and how it intersects with justice. But this is not often a priority again for social service workforce strengthening. But social workers can be really critical in supporting access to justice, informing children and families of their rights, documenting concerns and red flags, facilitating referrals to complaint and justice mechanisms, supporting participation without coercion or pressure, and acting independently, even under institutional pressure. And what we're seeing is this expansion again of social service workforces. They are being slowly professionalized, slowly capacitated, including as that backbone of the child protection systems. But in many countries, we see numbers, ratios, coverage, and capacity really limited still. So in planning and developing workforces, the role of the social service workforce in facilitating access to justice, including civil justice, must be deliberately built in and not seen as an add-on. And then access to justice across borders. In inter-country adoption, of course, access to justice must address the jurisdictional coordination between states, as we heard, recognition of foreign judgments that respect child rights, and cooperation. Otherwise, victims can be trapped between systems. And lastly, there has to be safe and effective remedies. As we heard, this is critical not only as a response mechanism, but also for a prevention mechanism as well. And international standards are clear that states have an obligation to deliver on this. So the brief on civil justice sets out those civil remedies that must be available. These include annulment or invalidation of adoption where legal safeguards were breached in line with the CRC Article 21 and the Hague Standards, restoration of identity, including correction of reissuance of birth certificates, restoration of original name, nationality, filiation, access to those sealed adoption records. There also needs to be mechanisms for family reunification and contact, including tracing and cross-border cooperation, establishment of resumption of contact with biological relatives, and then compensation and civil liability, as Benoit said, including for damages for moral and psychological harm, loss of identity and family relationships, costs linked to tracing and reunification, and civil liability may attach to adoption agencies, intermediaries, or other facilitators. For administrative remedies, there must be in place administrative investigation and review to investigate those irregularities and cooperate internationally to establish facts and responsibility. There needs to be access to records and truth-seeking. There need to be regulatory and disciplinary measures for adoption agencies, including suspending or withdrawing accreditation of adoption agencies, impose sanctions, and reform oversight mechanisms to prevent that reoccurrence as required by the Hague Convention. And then we need administrative reparation measures. This includes official acknowledgements or apologies, state-funded family tracing and social support, and administrative compensation or support schemes. So in conclusion, reimagining civil justice is a core child protection issue to prevent and respond to illicit adoption, especially in the development sphere, but it's a hugely underinvested area. It also cannot be pursued in isolation. We know that illicit intercountry adoption is more likely where child protection systems are dysfunctional or underdeveloped, and countries that impose bans to solve this issue without the systems reform, also going hand in hand, risk an increase of informal or underground practices. So as well as increasing attention and investment in civil and administrative justice for illicit adoption, Reform must be this integral part of a wider systematic child protection system strengthening approach. Back to you, Maud. Thank you.
Thank you very much, Rachel. I'm not going to repeat every time that you're also good complying with the time allotted. So that's the last time I'm saying it, and thank you for that. And thank you for a very extensive presentation of what it really means to have a proper functioning civil and administrative justice system, which will benefit those who have been subject to illegal adoption, whether it's the children themselves, the adoptive parents. So I'm not going to even try to repeat what you said, but I think I retain the term investment, and that's a term which means not only financial investment, but it means really devoting energy and attention to that, and not only focus on the criminal aspect of illegal adoption. Although I must say I'm very pleased to have heard you mention the intermediaries, because I think a lot of these problems start with the role of the intermediaries, as I've also identified in my reports on illegal adoption. So I couldn't agree more. That's a very good, important dimension. And of course, all the components to make the justice system works, which you have listed. So we're going to read your intervention again to have a clearer idea, but it's been very, very interesting to listen to you. So thank you very much, Rachel. And I now give the floor to Linda Reynolds, who is a member of Parliament in Belgium, and also in the same capacity as member of Parliament in Belgium. She is also member of the Interparliamentary Union. And a lot of things which she will tell us has to do with what's going on in the Interparliamentary Union. And I will be very happy to give you the floor, Linda.
Thank you very much, Maud. And you might tell from my accent that I'm actually Australian, Australian parliamentarian. There was everything else is correct, just wrong part of the world.
Went too fast. I'm so sorry. We anticipate
no problem. So
no,
thank you. And look, I'm very grateful for the opportunity to address this webinar today. I'm looking today, my contribution is different, a different focus. My background is as a minister implementing modern slavery legislation, taking up the international cudgel on orphanage trafficking, and now on intercountry adoptions. So my focus and my framework is how do we actually implement this and actually make sure that we can solve and deal with the problems. Because as we all know, and as a number of the speakers here have said, is that while we can recognise the problem and have it very well captured and fantastic resources and handbooks, it's actually very difficult politically, either in government or in the parliament, to actually get the changes that the nation signs up to in conventions and declarations and actually get them implemented. So in that, and I think that's in some ways the missing piece, and it's where I think the IPU, sufficiently engaged, can actually assist in these measures. So for me, the journey to here, and I see Linnell Long's came through Linnell, and I realised I'd been doing a lot of policy work in relation to out-of-home care. I became aware of orphanage trafficking, and it was well documented, but very poorly actioned. And I realised over time that this was a supply and demand issue, both for intercountry adoptions and also for orphanage trafficking. And it comes through the behaviours of those of us in receiving countries for both. And that we were creating a demand which either opportunistic or organised crime was only too happy to fill by commoditising children and adopting the methodologies that has been so well discussed here already. So from a political perspective, these are particularly wicked problems in many of our countries to deal with, because so for example, in Australia, we've had inquiries in the past, we've had selected moratoriums, but the problem we haven't fixed yet is how to actually confront people who are very well-intentioned, volunteers, donors, parents, people who are desperate to become parents, and their good intentions. And there's quite a streak of paternalism that runs through that, is that somebody else's children will either be better in a receiving country than being supported in their own countries. And it's also the perfect scam, because nobody wants to believe that instead of taking either through adoption or volunteering or donating to orphan children, they actually have in effect paid for them to be trafficked and then exploited in all the ways that we've heard here. So my approach has had mixed success here in Australia, and we've still got a long way to go, because it's, I think, like many countries, our population is quite distracted in a whole range of other issues and really don't see how it's relevant to deal with it here. So how I've approached both issues and out-of-home care is that children are children, and we need to determine here for our own children what standards and what care that we want for our own children. And as we know, it's a family, it's a sense of identity, it's a sense of community, it's a sense of love, safety, security, but also that issue of identity. But somehow we think that it's okay to treat other people's children differently because they're poor, or because we just accept at face value the story in the papers that we're told and that we're given. So perfect scam, the hardest harms that we do with good intentions are the ones that are hardest for politicians and people in civil society to get change on. So if you have a look at it as in the crudest way, issue of supply and demand. So those of us in receiving countries have created a demand to volunteer, to help, and to adopt. So if we deal with the demand side in receiving countries, and also then provide the assistance that other people here have talked about to those in sending countries, that will go a long way to dealing with both. But again, implementation is wickedly hard. And I've had a little bit, so in that framework, and having tried many different ways to get at the attention of the Australian Parliament and the Australian people, I, as a representative of Australia at the IPU, moved forward as a rapporteur a process for orphanage trafficking. And that was adopted unanimously by 180 parliaments. But the sticking point has been, we've got this great resource for that, and then now one on intercountry adoption, which you could just take both of those documents, give it to government and say, this is what you need to do to implement it. And AI now can do a great job in actually helping you say exactly what you need to do. But the trouble is actually getting government and getting bureaucrats interested, because once these things, if, for example, in Australia, we have been very, very slow in doing this, because we have a federation nation, states are responsible for the administration. They've all got very different rules. None of them comply with the Hague requirements. And so the list goes on and on and on. So getting through that bureaucratic inertia and finding new ways, not only for organisations such as those who are represented here today, but how do we actually get it implemented? How do we stop the demand? How do we help through all of the amazing ways that the presenters already have said? is the real challenge. So I look forward more to the discussion on some of the practical things. So some of the things that have worked in Australia and elsewhere, and how do we look at implementation as well as identifying the problem and how it could and should be dealt with versus how we can actually get things done in our democracies. So thank you.
Thank you very much, Linda. And once again, apologies. The only thing I got
Oh, no
right,
problem.
the only thing I got right is that you're a member of the Interparliamentary Union, but otherwise we're very grateful for all your efforts you are undertaking to raise awareness about the risks associated with illegal adoption, which can be illegal adoption, and to stop the demand and on the basis of a very practical experience. So thank you very much. And I apologize to all of you, all participants and attendees, because I need to go, but I will keenly follow the outcome of this discussion. Thank you for doing what you're doing, and have a great continuation of this webinar. Thank you so much.
Thanks, Maud, for staying with us. It's always great to have you with all your experience and all your passion to make sure that we respond properly to these illegal practices. So now we go to our next speaker. It's Ariane Vandenberg, who is not only the head of the Flemish Central Adoption Authority, but she's also the head of all child protection authorities in the Flemish part of Belgium. It's great that we can have you with us today, and thank you, Ariane, for being with us.
Okay, thank you very much, Mia. I'm still just struggling to see if I can share my screen with everyone, but it doesn't seem to work.
Let me try and do it as well. You can start speaking and then I will try and open up.
Maybe I can start already. So as Mia has introduced me, I've been the head of the Flemish Central Authority since 2012. That was a central authority that was created or established in 2005 at the moment that the Hague Convention was ratified in Belgium. We were rather late doing that. And that has also, it has an effect on the topic of today, responding to illicit practices, because it means that for quite a long time in Belgium, there was not very strong regulation regarding intercountry adoptions. And as in many countries, I think over the last years, we've witnessed quite a development. And since I've been working in adoption for quite some time right now, I've had the pleasure of witnessing from firsthand. So when I look back, like in retrospective, we see that starting, I think, around 2009, 2010, we've had our first reports coming directly from adoptive families and also from adoptees about practices in certain cases that were not quite up to standard. The first reports we got were coming from adoptions from Ethiopia in 2010, 2011. It made us look more deeply into the subject, trying to figure out what was going on. We went to the country, we tried to adjust the way we were working, but finally, I think in 2015, we decided that we could no longer work in that country because we had insufficient guarantees that everything was done properly. But this was not like an end point. It was just the beginning. I think as time passed, we got more and more reports about things going wrong. And those reports, they also, they got some attention first in media, and eventually it led to a series of hearings in the Flemish Parliament in 2019. And that was actually like the starting point of a long and rather far-reaching process where it all started with individual reports, but then it got a lot of attention. And finally, after the hearings in the Flemish Parliament, the government decided to appoint a panel of experts to have a closer look at the practice of intercountry adoption in order to receive recommendations how to things better. And that was, of course, the starting point for very extensive reforms and new legislation. But it also brought something else. It created the idea of investigating individual cases of illicit practices. I will talk a little bit more on both subjects, but maybe starting with a little introduction and retrospective. I think what is crucial, or what has been crucial in this development, was the lived experience. Individual stories of adoptees, but also advocacy by adoptee-led groups coming from India, from Korea, clearly telling us as a central authority that things were not done in a correct way in the past, and that we needed to pay much more attention to this. These voices of lived experience, they have been there for quite a long time, but what was really like a game changer was the first time that politicians really listened to the stories of adoptees, both the individual ones, but also the advocacy by adoptee-led groups. And then for the first time, there was like a different kind of thinking, a different way of thinking that started to emerge, where you saw that usually politicians mostly had an eye or an ear for the perspective of prospective adoptive parents. And then I think back in the years 2000, 2005, there was even a little bit of pressure on us as the central authorities to increase opportunities for adoption. And then gradually, they were changing their minds, and they were opening up to the idea of a more cautious approach, where we would focus much more on the idea that adoptions, they need to be carried out with great caution and with the best interest of the child in mind. So that was a very drastic change, where individual voices got they were reinforcing one another, and given the political response, it eventually triggered like a structural or systemic shift, also within the general public. But it was something that took quite a long time, and it happened over years. And this has led us to the situation where we are today. One crucial element in what happened was actually the appointment of an expert panel by the Flemish government. That was a direct result of the hearings that took place, where adoptees told us about their story about the malpractice that had occurred in their adoption. And the Flemish Parliament actually committed itself to bring clarity on the past of intercountry adoptions, still with an idea to improve future practice. So they appointed like a consortium of 4 universities that was supplemented by a number of experts with lived experience, and adoptees also having an academic background. The idea was they weren't commanded to do like an in-depth analysis of individual cases. They had more of a systemic approach. So they looked into the practice and the legal framework from different perspectives, a social science one, an historical one, an ethical one, and a psychological perspective. What was the impact on adoptees of the way intercountry adoption was organized back in the days? They did 2 years of research, mostly from that theoretical perspective, and then they came up with a very extensive report, concluding that the past and current organization of intercountry adoption in Belgium presented like considerable risk. So things needed to be adjusted or done. So they came up with a long list of recommendations in order to strengthen the system. So our former minister took that to heart and initiated a very intensive reform, reshaping the way intercountry adoption was being handled in the Flemish community. If you look at the recommendations made by the expert panel, it's not it's not something really new or innovative at first sight. They clearly stated that the best interest of the child needed to be the first and primary consideration in inter-country adoption. They also made it clear that we needed to be very, very cautious in our approach. Inter-country adoption could or should only take place at the explicit requests of the country of origin in order to avoid undue pressure, for example. They reinforced focus on basic principles such as adoptability and subsidiarity. They recommended to move towards open adoptions and eliminate the involvement of unnecessary intermediates and try to eliminate or strictly regulate all the financial aspects. Now, these ideas are not new, of course. So the biggest challenge was for us as a central authority to start thinking about how can we implement those recommendations in order to really strengthen the system in practice. So we try to translate them in a number of working principles that we implemented in our day-to-day work. First of all, there was a decision no longer to work with ABs, but to only work directly between central authorities in order to eliminate the involvement of intermediates, of contact persons, and also the financial aspects that were linked to that. The cautious approach that was recommended, we translated in a principle of working through a reversed flow, where we decided only to work with the files that were sent to us by the countries of origin, where they indicated that they were not able to find any prospective adoptive parents in their own country, but not also in the waiting lists of the PAPs of all the other countries. We decided also to work with a very limited number of states of origin, and only after a careful screening of both the child protection and the adoption regulations and practice. This screening development, we developed like a standardized screening tool in close cooperation with ISS, UNICEF, and CHIP, where I will be talking a little bit more about that in the next slide, with the idea that we first wanted to have a very clear idea on how the child protection system and the adoption system work in a certain country before we engage in a cooperation with that specific country of origin. We also made sure that it was not just a sort of exercise on paper. When we did the screening, I think in most of the cases, we also paid a working visit to the country in order to really see that the way things are done in practice, day to day, corresponds with what we have seen on the paper. And we also we developed our practice of a thorough review of all individual cases. There is like a very large advantage in not working with AAVs anymore, is that the child proposal and the file of the child, they were directly sent to us as a central authority. So it made it possible to do a very thorough scrutiny of all the documents present in order to verify that the adoptability was very clearly established, that we had a very good idea on the background of the child. Why did the child enter into the care system? Were there any efforts done to maintain or reestablish ties with the biological family? Were there any efforts made to have a placement in the country of origin? And it's like in working directly with the central authority of the state of origin, we were able to develop a practice where we got very extensive and clear information on each and every child that was placed in adoption in the Flemish community. Now, this is something that we have been developing over the last few years, but this was not like the end point, because about 1 year ago, we had the pleasure of having a new government and a new minister responsible for intercountry adoption. And very recently, there has been some debate in the Flemish Parliament about phasing out or stopping intercountry adoptions at all. This is not yet a formal decision, meaning that at this point in time, we are not yet there. There is still legislation that makes intercountry adoption possible under the conditions that I've set out before. So the cases are directly handled by us as a central authority, and with lots of guarantees on which countries we work with, on the individual files. But there is a strong political commitment to go further. To that extent, to make intercountry adoptions impossible for the future, our legislation needs to be changed, of course. So that means that a new bill or a new decree will be drafted in the near future. But since Belgium is like a federal state, it is not yet clear whether it will be possible for the Flemish community to make such a decision without involvement of the federal level. Because if you look at how things are organized in Belgium, it is actually the federal government or the federal level which is competent for the organization of intercountry adoption. So the basic conditions and the procedures, how procedures should be done, that is all regulated in federal legislations. The communities only have the competence in creating or deciding how preparation and screening of the PAPs is done, how they are guided throughout the adoption procedure. So how do we organize things? But the basic principles on intercountry adoption are set out in the federal legislation. So we are now in actually a very interesting time frame where we will have to engage in a dialogue with our federal colleagues and our colleagues from the French community on whether a change of the federal legislation is possible, and seeing as well what we can do on the level of the communities. I've added here, but I don't know if there's time for that, some more information on the screening that we were carrying out, screening of the countries of origin. I suggest, I think the information will be made available on the website of CHIP, so you can all have a look on that. Maybe I shall say a few words more on something else that we've developed. It is investigating individual cases of illicit practice. I think when the first adoption cases from Ethiopia were brought to our attention, where there were clear indications of illicit practice, the previous minister actually decided that all adoptees or whoever was directly involved in an adoption procedure, and anyone who has ever had doubts or concerns about the way the adoption procedure was handled, they should have the possibility to have their individual case investigated. So a review of individual adoption files mechanism was installed. Adoptees, adoptive families, and birth parents can come to the central authority whenever they have a concern for all intercountry and domestic adoptions, starting somewhere, I think, in the 70s up to 2010, 2015. We don't have like a very clear time limit, but most of the reports we got were from older adoptions. So our former minister launched like a call to report suspicions and doubts to the central authority. And then it all starts with like a personal interview of conversation with the adoptee, with the adoptive parents or with the birth parents to clarify what questions they have, what kind of expectations they have, and also to obtain their informed consent to share, for example, their adoption file with the person who will be doing the investigation. Now, the review is not done by the central authority, by our office ourselves. That would be nearly impossible. So we have decided to entrust it to independent professional partners, not central authorities, in each and every country of origin where we have a report or concern. Now, we have tried to identify potential partners in each of the countries for whom we got a report. And we decided to have them screened by International Social Service. We have a cooperation, an agreement with them, in order to make sure that each of those partners would be able to deliver like very professional, qualitative reviews of the files. We want to make sure that whenever we do like an investigation of illicit practice, that we do it in a way that is both very professional but also respectful in terms of talking to the birth parents, talking to the relevant actors in the country of origin. Now, I think, Mia, if you can go to one of the last slides. Yep. I have included.
It's just that we should leave a little bit of time for the judge from Chile.
Yeah, it's my last slide. If you can have.
Is it this one?
Yes, number 8, please.
Yep.
Yes, this gives you an idea. Up to now, we received more than 250 reports of possible illicit practices, which large numbers of India, Belgium, Ethiopia, and South Korea. But I think the most challenging countries to find like really good potential partners in the country of origin are mainly China, Russia, Ukraine, because of the situation actually there, and Rwanda. This was about everything I had to bring to you, and maybe I shall now leave the floor to the next speaker.
Thanks, Ariane. That's super, super helpful to see how a receiving state is proactively addressing illicit intercountry adoptions. I will now give the floor to Judge Aguilar, who's the judge from the Court of Criminal Appeals in Chile. Colleagues, if you would like to listen to him, you can go on to your interpretation into English, and then you will be able to listen to him. Thank you. Over to you, Judge Aguilar.
Muy buenos días a todos, a todas. Soy Alejandro Aguilar, ministro a cargo de la investigación de los delitos de adopción irregulares, designado por la excelentísima Corte Suprema de Chile el segundo semestre del año 2024. Llevo una investigación criminal, claramente es una investigación criminal en la que llevo, que partió bajo el rótulo de adopciones irregulares, pero al momento de asumir el cargo, cambié el rótulo de la misma y lo establecí como sustracción de menores, ya que las adopciones irregulares lo entendí como un eufemismo que de alguna forma no estaba tipificado en nuestra legislación a la época de los hechos. Me encontré al asumir esta investigación, que partió el año 2018-2019, tuvo algunas cosas, algunas dificultades con la pandemia acá en el país, y hemos tenido unos avances, y me encontré con un gran equipo investigativo a cargo de la jefa del equipo investigativo acá, de que está a mi lado, doña María Cecilia Erazo Venegas, que va a exponer brevemente también parte de esta exposición, que es la que lleva más tiempo en este tribunal. Le quiero decir como de importancia que yo investigo bajo las reglas del procedimiento inquisitivo. Si bien en Chile existe un sistema acusatorio, y en la mayoría del mundo occidental existe un sistema acusatorio, en Chile investigamos bajo la regla del procedimiento inquisitivo. Es decir, como ustedes bien saben, yo soy juez investigador, juez que acusa, juez que juzga y juez que condena. Es un gran peso en una sola persona llevar esta investigación, en donde es una investigación unipersonal que abarca todo el país. En consecuencia, como les decía, cuando me asumí esta investigación criminal, me encontré con bastante prueba documental de relevancia y consideré de importancia el viaje a recorrer el país recorrer el país porque mi competencia para esta investigación es una competencia nacional. Soy el único juez, el único ministro del criminal que está investigando esta competencia a nivel nacional y de los años, y los años que abarca es del año 1965 hasta la entrada en vigencia de la reforma procesal penal en cada una de las regiones del país en donde se implementó el sistema acusatorio. En Santiago es hasta el año 2005, por ejemplo, en Santiago, que es la capital de Chile. Entonces, mi competencia en Santiago para ver esta clase de delitos abarca del año 1965 al año 2005. Entonces, como les decía, me encontré con una gran prueba documental. Empecé a viajar a regiones para tomar declaraciones a las personas, a las víctimas, a las madres que habían sido objeto de estas vulneraciones, de estos robos de niños, de bebés, y me constituí presencialmente, en primer lugar, en el centro sur del país, a 150 kilómetros de distancia de la capital hacia el sur, en la ciudad de San Fernando, en donde entrevisté personalmente a madres de zonas rurales, analfabetas, con deprivación económica y cultural, con cero redes de apoyo, con cero redes de apoyo letrado también. Entonces me entrevisté con ellas y pude lograr ciertos éxitos hasta el momento, que consistían en que logré establecer que en esa ciudad del centro sur de Chile existía una asociación ilícita que estaba encargada del robo de niños, encabezada por una ex jueza en un tribunal que mediante un tinglado, mediante una especie de engaño judicial, esta asociación ilícita estaba compuesta por la ex jueza, por curadores, por abogados, por asistentes sociales y por personal civil y también por traductores. Entonces el personal civil que trabajaba para el tribunal, para la ex jueza, se constituía en sectores rurales de la ciudad de San Fernando y le decía a las madres que tenían hijos desnutridos que lo iban a llevar a un centro de nutrición de la localidad para alimentarlos, para que estuvieran sanos. Y cuando las madres iban a buscar a sus niños a estos centros de rehabilitación, CONIN, por ejemplo, se llama uno acá en San Fernando, no estaban, le decían que se fueran porque el niño no estaba y después aparecía, fuimos constatando que estos niños habían sido sacados del país con fines de adopción mediante justamente una tramitación judicial en el Tribunal de Letras de Menores de San Fernando, en donde estaba la jueza que luego de este procedimiento del siglo pasado, en los años 80, se fue fuera del país y yo a raíz de esta investigación, en este proceso, inicié procesamientos, inicié causa en contra de esta red ilícita de personas que sacaban niños y niñas fuera del país, esta red criminal, y pedí la extradición de esta jueza que salió fuera del país en la década de los 80, y a raíz de la extradición, mi más alto tribunal en el país, que es la Corte Suprema, se pronunció sobre el punto y estableció ciertos aspectos que me gustaría compartir con ustedes, porque al pronunciarse sobre la extradición que declaró procedente de esta jueza que salió del país cuando se estaba investigando estos hechos en la década pasada, los años 80, estableció ciertos acápites interesantes que primera vez que ocurre en Chile como una investigación criminal. Estableció que dada la naturaleza de lo ilícito que se imputan a la requerida, estamos en presencia de hechos imprescriptibles, de modo que el hecho de que se trate de conductas que se verificaron en la década de los 80 del siglo pasado no es obstáculo para la persecución penal. Además, agrega que la imprescriptibilidad emana de la naturaleza de los bienes jurídicos afectados por los hechos en que descansa el pedido de extradición, con el carácter de derechos humanos irrenunciables y que dicen relación con el derecho a la identidad y el derecho a la reunión de la familia, entre otros derechos fundamentales, el derecho del niño, el que están consagrados en la Convención de Derechos del Niño. Además, señaló que estos hechos constituyen múltiples y graves violaciones a los derechos humanos, lo que ocurrieron en la ciudad de San Fernando. Además, indicó que por otra parte, como se indicó, establece el más alto tribunal, lo que sí es posible observar en las prácticas atribuidas a la requerida es que se trata de hechos que vulneran gravemente los derechos humanos de las víctimas. Esto es, bajo dos vertientes, las madres que han sido despojadas de sus hijos y los niños y niñas que han sido arrancados de sus familias, perdiendo toda vinculación con su origen e identidad. y tales hechos vulneran la Convención de Derechos del Niño y otros tratados internacionales que ha suscrito Chile. Y establece de forma tajante, enfática, como lo establecí yo en primera instancia, que según se ha razonado, estamos en presencia de crímenes que vulneran gravemente los derechos humanos, de modo que se trata de ilícitos que tienen el carácter de imprescriptibles. En consecuencia, este fallo reciente de la Corte Suprema de Justicia de Chile estableció que estamos en presencia de graves violaciones a los derechos humanos, obviamente de hechos imprescriptibles. Además, hubo 2 votos en este fallo que establecieron que estaban en presencia de delitos de lesa humanidad, es decir, que hubo un ataque generalizado contra la población civil en la década que se investigó y que por lo tanto debían ser regulados conforme al artículo 7 del Estatuto de Roma, que estableció la Corte Suprema, que es un artículo de aplicación general más amplia, con interpretación más amplia en beneficio de las víctimas. Ese voto de minoría mantuvo mi criterio que estaba en presencia de delitos de lesa humanidad, no obstante que el voto de mayoría fue que eran graves violaciones a los derechos humanos, igual gravísimo, imprescriptible, con vulneración flagrante de los derechos de los niños y de las madres vulnerables, deprivadas social y culturalmente. Bueno, siguiendo con esta investigación, he tenido también, como parte de mi trabajo, reuniones con autoridades, tanto locales, con ministros del gobierno, de Cancillería, del Ministerio de Justicia, de reparticiones públicas, y también con representantes o embajadores también de ciudadanos de países extranjeros, especialmente europeos, en donde se fueron varios niños y niñas hacia dichos países. Y lo que le llama mucho la atención, especialmente a los representantes extranjeros y a las personas, a los ciudadanos extranjeros que vienen acá a preguntar por su causa, porque aquí al sur del mundo se está investigando criminalmente los hechos que ocurrieron en la década de los 80, 70 y parte de los 90, señalan que le llama mucho la atención el procedimiento inquisitivo, lo cual yo soy parte, que es un procedimiento escrito, como ustedes saben, bajo secreto sumario, donde reúno facultades yo de conocedor, juzgador, acusador y sentenciador. Y como conclusiones finales puedo decir que esto de constituirme en sede en las sectores rurales, lo estoy haciendo ahora en todo el país. Estoy recorriendo todo el país de la República de Chile, especialmente la zona sur, en donde se desarrollaron la mayor práctica de actividades de adopciones ilegales, de sustracción de menores, con el fin de lograr justicia en estos casos concretos y avanzar en el éxito de una investigación criminal que llevo adelante desde el año 2024. Aquí va a dar si me permite, señora moderadora, va a dar unas pequeñas estadísticas la jefa investigativa del tribunal. Muchas gracias.
Buenos días en Chile, buenas tardes allá. Desde esta circunstancia podemos señalar de que ha existido una evolución histórica donde se ha generado que se ha llegado a esta fecha a investigar criminalmente la situación de sustracción de menores y de alguna manera u otra entender cuál fue el proceso previo para ello. Dentro de las décadas de los 60 y los 70 han existido algunas investigaciones individuales por sustracción de niños, lo cual era bastante poco habitual ya que existía un cuidado de los niños de una manera más comunitaria. Sin embargo, en la década de los 80 y 90 ya comienzan las denuncias individuales que dan cuenta de irregularidades reiteradas, tanto irregularidades reiteradas en Chile, pero también en procesos de salida del país con fines de adopción, identificándose actuaciones específicas de algunos juzgados de menores y también se conocieron y se buscaron respecto a las mujeres desaparecidas en contexto de violencia política que podrían haberse encontrado embarazadas. Pero es a partir del año 2000 que ya se comienzan y se intensifican las investigaciones por sustracción de niños y otros delitos asociados desde los hospitales públicos, con participación de médicos, de miembros del clero, de religiosos, de funcionarios judiciales, notarios y otros. Si bien en esa fecha no había sido posible establecer el paradero de la mayoría de ellos y cuál era la maquinaria que existía a la base, sí se pudo establecer que habían salido del país, pero se desconocía el país de destino y el mecanismo utilizado. Tenemos un video que acompañamos solamente para efectos de ilustración.
Miles de niños y niñas fueron arrebatados de sus madres en Chile. Entre los años 60 hasta el 2000, una red de adopciones ilegales operó en el país, especialmente durante la dictadura, separando familias y enviando a más de 20.000 niños al extranjero sin su consentimiento.
Thank you for this video. I think that unfortunately we've come to very much the end of the webinar. So I can give you 1 minute to finish up just because people need to close in 5 minutes. Sorry, because we could do a whole webinar just on Chile, I think.
Sí, claramente lo único que es interesante saber es respecto de los periodos. Los periodos que, si bien tenemos mayor cantidad de denuncias, es del año 65 al 88. El segundo periodo es del 88 al 99 y el tercer periodo ya es más corto, a diferencia de lo que presentaron los expositores anteriores. Y finalmente, respecto a quién es el interesado en iniciar las causas, que hoy día existen 1.529 denuncias propiamente tal, principalmente es la familia de origen, pero ha existido un movimiento durante el último periodo que ha incorporado el interés de los adoptados que se encuentran en el extranjero, que pueden realizar las denuncias en Chile. Y finalmente, respecto de esta circunstancia, si bien nosotros hoy día tenemos 1.530 causas en tramitación, tenemos más de 25.000 registros de niños que habrían salido del país con fines de adopción. Por eso es el interés actual del gobierno de Chile y del Poder Judicial para trabajar esta temática. Muchas gracias.
Thank you, Judge Aguila, and thank you to the lead investigator. You're doing an amazing job to deal with such complex cases and so many hundreds of families affected by this. I think that the world can learn from the way you're processing these cases and visiting the many families and the children, especially also including intercountry adoptions. Unfortunately, we only have 4 minutes left for the webinar. So what I'd like to do is ask the speakers in order of who spoke, if there could be one activity that a state should prioritize in responding and preventing illicit intercountry adoptions, what would that be? I would give the floor to Benoit first, and then we move over to Rachel, and then to Laura, and then Rachel, and then also we move along that way. Benoit, over to you.
Yes, Mia, I would say the guarantee for non-repetition for me is crucial. We have seen and we now have proof of all the wrongdoings for years and years, but still I can see that states do not take lessons from that. So guarantee for non-repetition, individual complaint mechanism, collective complaint mechanism, and access to mechanism to know your the origin. All this goes together. Thank you.
Perfect. I hope the states are listening. Laura, what would you recommend to states to prevent and respond to illicit intercountry adoptions?
Thank you, Mia. I think it's extremely important to have strong safeguards, transparency, and as well, I think is to have a clear accountability so that we have oversight. And then I think we have to focus on two things on prevention, but we also have to focus on everything of addressing what has happened in the past and how take into consideration that. And there, I think we have always to take a right-based approach, and it's very important to have the views of persons with lived experience taken into consideration. I think this is key. Thank you again for the opportunity and the invitation.
Thanks, Laura. And Rachel, from UNICEF's perspective, if there was a recommendation you could make to states, what should they prioritize?
Thank you, Mia. I think that my presentation very much focused on this holistic approach to combating illicit adoption on protection and justice. But within that, the recommendation is don't have civil and administrative justice as an afterthought. It has to be an integral part of system strengthening from the outset to really enhance prevention and ensure that you have that effective and comprehensive response. Thanks.
Thanks for that, Rachel. And Linda, speaking as a former senator and a member of the IPU, Inter-Parliamentary Union, what would you think would be a good one for parliamentarians and states?
Look, I think we need to find a way in each of our countries to have a conversation with our people and actually get a burning platform. It could be the voices of the victims and the families, but we need something to actually ignite interest in it, not only to get some champions, but also to encourage government to act, but also for people to change their own behaviours in how they volunteer, donate, and how they adopt and where they adopt from.
Thanks for that, Linda. And Judge Aguilar, as a leading country in terms of responding to illicit practices, what would you recommend to other countries that are going to have to be courageous, like Chile? Would you have a recommendation to other countries? What lessons would you give them?
Como un simple operador del sistema judicial chileno, yo creo que incentivar y promover la investigación criminal y la búsqueda de la verdad, justicia y reparación de las víctimas de estos hechos. Eso se le diría, señora moderadora. Y ahí usted, María Cecilia.
Y recogiendo lo señalado por Rachel, me parece también que para investigar también se necesita la integralidad porque uno abre heridas en esta investigación y poder cubrir integralmente desde el ámbito psicológico y social y jurídico a las víctimas también sería necesario.
Muchas gracias.
Okay, thank you very much to our speakers today. Thank you to the participants. It's been a very rich webinar. We've learned a lot in terms of different activities that are doing their best to prevent these illicit practices. Probably it's not fast enough, given that many of the children are now adults, and as adults, they're aging, their families are aging. But we look forward to continuing not only the conversations, but working together to make sure that there is access to justice and effective remedies, not only for the children, but for the birth families, and also in many cases, the adoptive families that were not necessarily participating in these illicit practices. We look forward to working with states, and the recording will be on our website, on CHIP's website, and we will be in touch about future initiatives to move us forward in our work together. Thank you, everybody, and have a good rest of the day. Bye-bye.